Honors. Michael Roberts for the respondent, Hawk One Security. May it please the court.
I'm sorry to jump in right away, but I was wondering if you could elaborate on Judge Glickman's question. I thought it was odd that the employer submitted the O'Denoran case and brought it to our attention when arguably it might be more beneficial to the petitioner.
Yes, Your Honor, that is correct. It is a case that doesn't necessarily support our position in this case. It's important looking at the O'Denoran case and the Doyle case from today, because it's this court elaborating on the distinction between misconduct and gross misconduct, between simple and gross. It's important looking at those cases. This court hadn't, prior to those cases, this court hadn't really expounded upon the distinction between those two standards. And both in the O'Denoran and in Doyle, this court notes that to get from simple misconduct to gross misconduct, we're looking at conduct that's more egregious. I think O'Denoran said, very serious indeed is the standard that they're looking at. So we need more than just, literal fitting within the definition of gross misconduct. O'Denoran said that just because there's a literal satisfaction of the gross misconduct standard, that does not mean that there was gross misconduct. You need to look at the examples that are provided in the regulation for color to that meaning, to understand whether this is truly the type of conduct that was intended to be gross misconduct. So you're correct, Judge Rigsby, that O'Denoran does make it a more difficult case for us because it more fully elaborates that standard. However, I think you also hit it right on the head when you indicated this was not just a verbal argument. Admittedly, the civil misconduct standard includes profane language, abusive language, but that's not what we had here. Certainly we had profanity and abusive language, but we had a lot more in this case. Judge, as you noted, there was pursuit down the hallway, and she got in her face. Officer Brown testified that even after Officer William turned around, they continued to move into each other's faces. So there's both a physical element here and not just a verbal element. And very important in this case is the context. And as you also noted, this was a situation where we had uniformed officers, trained special police officers that were hired to maintain order and control in that school building. Petitioner argues that perhaps students didn't actually see the encounter that took place, but the finding here wasn't that a student saw it, but that it took place in front of students. And that's amply supported by the videotape in this case. And also, Officer Brown testified in this case that this whole incident took place no more than 3 feet, perhaps just 1 foot, outside a cafeteria door where students were being held in a tardy hall that morning. So I submit that there's substantial evidence in the record that there were students present, that this was inappropriate conduct under the circumstances.
In deciding whether it is misconduct or gross misconduct, how should we factor in the fact that Ms. Brown's behavior in following, I forgot the name of the sergeant, but following the sergeant and taunting her was provoked by the sergeant's threat against her? And it would seem as if it could have been argued that the provocation mitigates the misconduct from gross misconduct to simple misconduct. How do you respond to that?
That's a very good point, Judge Glickman. This court has held that the provocation doctrine does apply to the unemployment context, specifically to findings of simple misconduct or gross misconduct. Petitioner didn't argue that below. The evidence in the record from Officer Brown herself was that she considered her actions. She thought she was acting pursuant to the guidelines. So she had knowledge of the employee training manual. She applied that mentally in deciding to take the particular actions that she took. So it's clear that it was deliberate in this case. And also, there was no argument about provocation, but the standard in this court for provocation, I think most recently, or at least a good statement of that is from Brown v. U.S. 584 A. 2nd 537, which is whether the conduct at issue would cause a reasonable, ordinary person to lose his or her self-control and act without reflection, and if so, whether the person in fact was provoked by that conduct. Here there's very substantial evidence in the record that there was reflection here by Officer Brown as she considered the options available in her understanding under the manual. And so
that's just argument of counsel. She wasn't thinking about the manual when she It's hard for me to believe. Did she testify that she was thinking about the manual?
Actually, Judge Glickman, she testified word for word. She missed one little phrase, but her testimony was word for word exactly to the manual. Granted, that was probably a trial tactic.
I mean, it's one thing to say the manual justifies what I did. It's another thing. Did she testify that in response to the sergeant, whose name I'm blanking on, the sergeant's threat, she thought to herself, oh, well, the manual says I ought to address it. She didn't testify to that, did she?
She testified, she was asked, why did you do the conduct that you did? And she said, because I went through training with Hawk One. Training told me conflict happens, conflict happens, and an officer pursues it or something to the effect, which literally word for word comes out of the training manual, except for she conveniently omitted a phrase that clarified that you also analyze all circumstances and the appropriateness of the conduct. But I'd also submit that even if she wasn't actively engaged in this thought process, which, she testified that she did, but even if she did not, the conduct at issue here does not meet this court's definition of provocation, especially considering the circumstances. We have a trained security officer.
Where that definition of provocation, you're taking that from a criminal case, involving manslaughter or something?
It was a criminal case. I believe that was a case involving vandalism to a home over domestic disputes. And a malicious destruction.
It's a somewhat different context.
It is, Your Honor, but this court has indicated, I don't have the site in front of me, but this court has indicated that the provocation doctrine does transfer. I believe the Williams case in 1978 indicated that the same provocation doctrine would apply, but this court has said more recently, has reiterated that point, that it is fair to apply that to the intent doctrine in the gross misconduct standard.
Any other point, Mr. Roberts?
No, Your Honor. If there are no further questions to the panel, we would ask that the decision below be affirmed.
Very good. Thank you, sir.
Thank you.
Mr. Schwartz, rebuttal.
Thank you, Judge Reed. Let me say that there was absolutely no testimony and nothing in the record, much less substantial evidence, that Ms. Brown engaged in any profanity whatsoever. And there was absolutely no testimony in the record.
You're correct on that. I was referring to Sergeant Williams' profanity, and Ms. Brown's response was verbal, and she did not use the same profane words or any profane words. So you don't have to argue that further. I stand corrected.
Well, I didn't mean to correct you. I meant to correct Mr. Roberts, who, by the way, has shown remarkable professionalism in not only in bringing this to your attention, but in pursuing this matter. Secondly, there's no testimony whatsoever that they went into each other's faces, as Mr. Roberts said. All she did was follow her down the hall. Sergeant Williams stopped, swung around, and hit her in a matter of a second. There was no confrontation.
There was no confrontation. Following someone down the hall doesn't constitute a confrontation. I think that we could point to some criminal cases where we've said that when someone turns away and begins to walk away and you pursue them, that under other circumstances would constitute a confrontation. But
well, it's
I know we disagree on this point, Mr. Schwartz, so I won't keep...
Okay, but the final point, or next to final point, is the manual. She did not stop and think. She really didn't stop and think at all during this confrontation, but she didn't stop and think and say, what would this manual have us do? Her training was, if there's any kind of confrontation of any kind, either with students or with anything, that you need to resolve it right away while it's fresh. There needs to be a face-to-face meeting, and that was in the training. And that happens to be the way that they are trained. They react instinctively.